Good day and welcome to Learning Thursdays. I am Dave Kruder with the OASAS Learning and Development Unit and your host for today's presentation. Today's presentation is titled, Know Your Rights for Substance Use Disorder and Mental Health Treatment and Insurance. Our presenters today are Rob Kent, New York State OASAS General Counsel, Tricia Allen, New York State OASAS Senior Attorney, and Stephanie Campbell, Project Director for the Substance Use Disorder and Mental Health Ombudsman Program. They will be joining us in just a moment. First, a word about Learning Thursdays. Learning Thursdays are offered to addiction professionals as a free learning opportunity with the goal of improving the knowledge and skills of the New York State substance use disorder workforce. We strive to improve the lives of individuals needing prevention, treatment, and recovery services. A goal of Learning Thursdays is to support the professional development of the treatment, prevention, and recovery workforce. We do this by offering regular presentations that are relevant to today's substance use disorder treatment professional. As always, if there are any questions, comments, or suggestions, please feel free to contact us at the Learning Thursdays mailbox. You can use the same mailbox to express an interest in providing a future Learning Thursdays program. And now it's time to start the presentation. Welcome to our presenters.
Hello, I'm Rob Kent. I'm the New York State OASAS General Counsel. We're going to talk to you today about insurance rights and access to treatment as it relates to coverage for insurance. Joining me today.
Hi, my name is Tricia Allen. I'm one of the attorneys in counsel's office at OASAS. I work with Rob Kent.
And I'm Stephanie Campbell. I'm the project director for the SUD Mental Health Ombuds program, otherwise known as CHAMP.
So questions that come in as it relates to this presentation, you can send to the email address on the slide that we just showed. So we wanted to lead in, we could make this a very bland conversation about insurance law and appeal rights and all kinds of acronyms. We're government, we love acronyms. But more and more as we've worked in these issues, and we wanted to make this point, overdose does not discriminate. Stigma equals death. We didn't create that. We use it. It has origins way beyond the HIV/AIDS epidemic, but silence equals death was what was used there. What we've observed as we've been addressing, access to treatment, insurance coverage as it relates to the opioid epidemic, so much of what impacts is not just the laws and the rules, but also the stigma associated with the disease. The stigma impacts the way the laws were written, which we've been trying to rewrite. It also impacts people being willing to access treatment and ensures providing coverage for the treatment while people are seeking it. So as that is a lead-in, we've spent a great deal of time in the last number of years under the leadership of Governor Cuomo and our Commissioner Arlene Gonzalez-Sanchez, trying to eliminate the barriers to accessing treatment for those with public insurance, be it Medicaid, Medicare, but also private insurance, commercial insurance. Just need to make a couple points though as we move forward, and which one of them is the following. So government acronyms, ERISA. There are insurance policies that are protected by a federal law called ERISA, and I think we go into it a little more detail as we move forward. So just so people understand context, about half of the insurance policies in the private insurance market written in New York State are not protected by New York State law. They're protected by federal law. So with that qualifier, as we go through what we're going through today, the laws, the appeal rights, everything that we're going to talk about today relates to those policies that are covered and protected by New York State laws. The other set of laws, as I said, ERISA, protected insurance plans, which we will explain. We can't impact those insurance policies. Unfortunately, that's something the federal government addresses. So, stigma. Mental health stigma leads to feelings of shame, poor treatment outcomes. These are research studies. I'm not going to read this stuff. I've explained to you. Stigma impacts people accessing treatment, and it impacts people receiving coverage and providers being paid for providing that treatment. It still is a major issue. We could do a separate Learning Thursday, and we've done those, and we'll do more in the future explaining how we're trying to break down the stigma. But this program is intended today to focus in on understanding coverage rights for private insurance and Medicaid. And, you know, so as a menu and a lead-in today, and I'm going to turn a lot of this over to my colleagues who work with me on these things, we're going to explain some of the definitions that apply in this world, talk about where the New York State laws do apply, what is covered by commercial insurance, what is an in-network provider, what is an out-of-network provider, what's utilization review, what is an appeal process, what is the Ombudsman program, which Stephanie just introduced herself as our project director, some common questions and resources. I would encourage all of you, watch this video, share it. We were going to post it on our web. It's free, it's available. The more we can make people understand what they are entitled to when they have a private insurance policy, the better off we all are, the more people who can access care, and obviously the easier it is to help people get to a point of recovery in their lives. So with that, Tia, do you want to talk about some of the definitions?
Sure. So the thing that I will say that is most important when you're looking at insurance coverage is really understanding the details behind your contract. Typically, you have a document that you get from your insurance company that lays out what services they're going to cover, what steps you need to take in order to access a particular provider or type of service. So that document really is very important to read through and understand. However, I also recognize that reading an insurance contract is probably not an excellent way to spend a Saturday. So a couple of brief definitions, and then I'll cover a couple of other items, and feel free to chime in if I miss anything or if you want to add anything. And the first thing to know is when you say that something is covered, all that means is that your insurance company has agreed to pay for that service. If you're talking about networks, part of a lot of insurance policies is an agreement between an insurance company and a provider saying that that provider agrees to accept that insurance company and the payment that they've agreed to for a particular service, so that provider is now in the network with the insurance company. Another key word or topic is utilization review. So this is simply the process that an insurance company has to look at a service and determine if they're going to pay for it. So this may be what's known as a medical necessity determination, which is a common word that you hear when you're seeking services. But they're trying to determine if the service was appropriate for someone to receive. And then appeal. So an appeal is a process that you as the consumer, the person who has a contract with the insurance company, or somebody that you ask to do so on your behalf, like your provider, they can go to your insurance company and ask your insurance company to look at a decision to not cover a service. So if you ask for outpatient treatment and your insurance company says no, you or somebody that you designate can go back to the insurance company and just ask them to take a second look. And we'll go through, there's an entire process and there's quite a few timeframes to be aware of, but that's just an upper level definitional starting ground. So a couple of things to be aware of on the federal level. There are two laws that were enacted. The Mental Health Parity and Addiction Equity Act, or MPEA for short, or Parity as it's more commonly known, was a federal law that was passed in 2008, and I think they've done a few regulatory updates, I think 2013, 2016 maybe, most recent. You hear parity said a lot. So parity is applicable to insurance companies, and all it means is the insurance company has to provide coverage for, if they provide coverage for mental health and substance use disorder services or behavioral health services, they have to do so in a way that is on par or similar and comparable to the way they treat medical surgical benefits. So for example, if I were to go to a doctor who was a specialist for my foot, I hurt my foot, and I go to a doctor for my foot. And there's no prior authorization for that. I just walk right in. I don't need a referral or anything like that. But then on the SUD side of the world, maybe you need to go see your primary care doctor first before you can go to an outpatient visit. And you have to have a prior authorization conducted, and they have to review every single day that services are provided. That is a very blatant example of how the coverage wouldn't be provided in a way that's comparable, because the requirements and the structure set up around the SUD benefits is so much stricter than it would be on the medical surgical side.
But it's a floor. So in other words, a lot of the things that we've done in New York State that impact New York State policies, we've exceeded parity.
Exactly.
Eliminating prior authorization, other things like that. So parity is wonderful that there's a minimum, but states are permitted to exceed the parity law.
Exactly.
Great.
An additional change that came about was the Affordable Care Act. So this was in 2010, I want to say. So. Might be wrong on the year. So essentially it just said that these specific benefits are essential health benefits that have to be covered. SUD was included in there. It also references medications, and the Affordable Care Act actually speaks specifically to naloxone, which we'll get into later about why that's so important, and how you have to, as an insurance company, cover naloxone because it's the only formulation or type of that medication that is currently in existence. So, all right, first question you need to ask when you're talking about somebody, about your insurance company, is my policy even covered by New York State law? Rob mentioned this earlier. A lot of insurance policies aren't, because they're issued by other states. They're issued by specific, like ERISA plans, who are not subject to New York State law. They're actually subject to federal law. So there is a website that you can use that you can look up and determine whether or not the insurance company is regulated by New York State. So I've included the web link on the presentation, and if you go to that web link and type in the insurance company name or just type in the type of insurance, it can pull it up. So this is what I was speaking to earlier. There are two circumstances where New York State laws would not be applicable. The first is self-funded or ERISA plans. So these are Employee Retirement Income Security Act. That's what ERISA means. And these are employer or employment group designed policies. They kind of, as a group, set their benefit package, and they also kind of determine what services will be covered, to what extent. They set their own standards, and they are subject to federal law, not subject to state law.
So you mean if I'm a farmer, I'm going to have a different insurance plan than if I were a banker?
Not necessarily. So typically speaking, a self-funded plan is more like a larger group plan, or I think if you look at I'm going to say Acme because I don't want to name a specific company. But say you have a large company
like
that's
a multi-state
in multiple states. So New York, Connecticut, New Jersey, Florida, you know.
Well, we're not going to say, we would say something else, like
Acme.
Martwall.
But we don't, actually I don't know which state their policies are written in, but the laws of that state apply to those insurance policies, regardless of whether you live in the state it was issued or not, but you're covered by it.
That's helpful.
Yep. So when you talk about self-funded or ERISA plans, the other thing I will note is for the plans that are regulated by New York State, a lot of what you'll see is Anthem or Fidelis, you know, common insurance companies that we hear about in New York State. Instead, it's actually the employer who will manage it, or they might have a third-party administrator manage it, but it's not an actual insurance company who's taking on the risk, paying the claims, that kind of thing.
So how do you know if you have that third party?
You have to ask. You really have to do a little bit of digging to try and figure out what it is that is applicable. I will note that there is a resource available for ERISA plans at the federal level when you have concerns. that you can look into, I think it's the Employee Benefit Services. They can actually assist you if you have any concerns about a claim or maybe the treatment that you're receiving under your
But the
ERISA
most
plan.
important foundational thing is that contract you talked about.
Yes.
Even though it might be very tedious to read, it explains everything they cover and all the process they use to determine whether or not you're eligible to access a benefit they might cover.
Cool.
Okay. So what do commercial New York State plans cover? As a result of legislation, which Rob mentioned earlier, the federal level efforts as well, there are some basic benefits: inpatient and outpatient services for both substance use disorder services and mental health services. I'm apologizing now because I'll probably mix SUD and OASAS up a lot, but they are covered services. Another thing that I will notice is that there is no denials for pre-existing conditions. I think that's something that's really important, especially in our world, to just throw that out there and make it very clear. If you get a notice from a New York State plan that something's not covered because you had it before you got the insurance, you really need to bring that to the state regulator's attention, which is Department of Financial Services in this case. Okay. So we have done a lot of work around the SUD world to ensure that people have rapid access to care. So I'm going to break this out into a couple of different parts. Bedded care, which includes detox, inpatient rehabilitation, and then some residential care. So that would be for our 820 services, stabilization and residential rehabilitation. And then also Part 817 RRS-wise, those are bedded services that are covered. And we also provide for access to those services rapidly. So if you are in New York State, you are covered by a New York State policy, and you are seeking bedded care, if you go to an in-state, in-network facility, you have immediate access without prior authorization, and provided your program determines that you're appropriate for that level of care and communicates with your insurance company within 48 hours, they are not able to do concurrent review for 14 days. There's
They have to communicate you've been admitted.
Yes.
They don't have to seek permission to let you come in or to have you stay. They've used a tool, which we'll talk about, that we created.
Yep.
You're appropriate for that level of care. You can go in immediately, and you can stay there for a period of time. Ultimately, it's for as long as you medically need it, but there's a process that we'll talk about.
Yes.
What if somebody says that I could go, or my loved one could go to a place in Arizona or Pennsylvania?
So, you could. You absolutely could go to Arizona. What I would say is we don't live in Arizona. So.
That's true.
We don't know anything about treatment in Arizona.
That's true too.
We don't regulate Arizona treatment programs.
And the argument that you're going to have with the insurance company about coverage for services provided in Arizona, that discussion is going to look a lot different than what you would have if you were to seek treatment in New York State. Part of the provision that we have is if a program admits you to care and they believe that you're appropriate for care, you stay there for as long as is medically appropriate, but there's no concurrent review until the 14th day. You know, should you stay longer than that.
So concurrent review, what does that mean?
Sorry. So concurrent review, that's essentially where the insurance company is saying you are currently receiving services and we are looking at those services to determine if you need any more. Prior authorization is where they're looking before you get any services to determine whether or not you should have access to them.
So an important distinction then is that, as you talked about, in-state. So if you go to Arizona, these rules we're talking about, even though it might be a New York State insurance covered policy, don't apply.
Ah.
Because
so you might not get coverage anyway. They could make the case that.
Well, it would most likely as well, are they in network or out of network? They're probably out of network. So you're accessing, so the first question would be, do you have out of network coverage in your insurance policy? And then it could be subject to prior authorization, immediate review, or a review every other day. and significant copays usually. It varies, but we've seen everything from you're going to pay 20 to 30% of the cost. The other key component is if you're in network, the insurance company has settled on a price they will pay you for the services. Not just that they cover the service, but what they will pay for those services. If you go out of network, including out of state, they get to charge whatever, quote unquote, their reasonable, usual and customary cost might be. We know of examples where that could run into the 6 figures.
Wow.
And you would owe 20 to 30% of that.
Wow.
The final point that I will make is with all of the provisions that we have that allow for immediate access to care, there are limitations on the impact to patients. So if a provider determines that somebody is appropriate for care and the insurance company disagrees, the dispute is between the insurance company and the in-state in-network provider. There's a provision in there which specifically says that the patient is held harmless from those costs. That is not the case in Arizona or any other state.
So to maybe expand on that a little bit, what that really means is you went to a bedded treatment program in New York State on a New York State policy covered by our laws. The provider determined front end it was medically necessary using our tool. You went in, you stayed for 20 days. The insurer can do what's called a retrospective review. They can look at everything after the fact, retrospectively, and they could say, you know what, as of day 11, you didn't need to be there. So days 12 through 20, what used to be the case before we enacted these laws was, hey, you, Mr. Consumer, and your family, you owe us for days 11 or 12 through 20. When we changed these laws to allow immediate upfront access and tried to balance all the different interests, we said to the world, days 12 through 20 are now a fight between the appropriate parties, which is the insurance company and the provider, and the family is held harmless, right? So
the next point that I did want to make to kind of loop onto that is we did similar actions for outpatient care that happened just in this past year. The no prior auth or concurrent review is for the time period of the first 2 weeks of outpatient care, not to exceed 14 visits. So there is that ability to get in, have an assessment, maybe talk to a peer, see what it is that you need, but the outpatient program and the patient have time to really understand what the patient needs, get into a rhythm, and go.
And that's been the whole point, is we wanted people, when we enacted these laws over the last 4 years, the basis for them was the following. The governor created a task force, the lieutenant governor, and our commissioner went around the state. One of the things they heard, and this was in 2016, I'm sitting with my loved one trying to get into a bedded program, an inpatient program, a residential program, and at that point there was prior authorization. So they might sit waiting for the insurance company to make a decision about you can go in or you can't for 6 to 8 hours. Now, if you're using substances at about maybe hour 6, maybe earlier, of not having used, waiting in the waiting room, you're going to start to go into withdrawal. And what we found is they either excuse themselves for a period of time to eliminate the withdrawal, or they go into withdrawal, or what we heard far too frequently, we're leaving because it's not meant to be. So we wanted to eliminate that. And then we wanted a period of time for which the individual could be with treatment folks getting better, stabilizing, before you start interfering and making decisions about whether they need to be there and for how much longer. I want to make this point. So it's 14 days in both bedded and outpatient, and the world has sort of defaulted to, well, you only get 14 days of treatment. That is not the rule. That is not the law. We said there's no interference for the first 14 days. We did not say that's all you get. If you need 20 days, you should get 20 days. You should get all the care you need that is medically necessary. The problem is the way our world has sort of evolved, everyone's defaulted to 14 days, which depending on the timing of this show, which is why the governor put forward in his budget for fiscal year 19-20, we want to extend that to 21 days, because our thought is if everyone's going to default to the easy, which we made 14 days, why not make it 21 to give a person even that much longer to stabilize in treatment? So I want to be clear with everyone, if you hear that from a provider, well, they'll only cover 14 days. The response should be, well, I was told and I watched this video and it said I'm entitled to all the care I medically need.
On the flip side of that, just to,
yeah.
I will note that there are certain cases where you may not be appropriate for 14 days. You know, there are definitely certain levels of care where the intervention is a lot shorter. So, you know, just because the law says 14 days, just like Rob said, that doesn't mean you're going to get 14 days. It may be shorter, it may be longer. The other thing I will add is that 14-day clock that we're talking about is specifically related to the time when an insurance company can kind of intercede and discuss with your provider what services you're going to get. But that clock starts or restarts, I guess you could say, when you go to the next level of care. So say you start at a detox unit. You may be appropriate for 3 days in a detox unit and then be connected to an inpatient or a residential service. So the clock would restart when you got admitted to the inpatient or residential service. And then you would have a discussion with that provider. They would be conducting a clinical review of you to assess your appropriateness for that level of care, you know, every couple of days. And periodically they would be talking with your insurance company to just make sure that everybody is aware that you're in the program. Maybe they're letting them know what kind of progress you're making. And also, you know, we say that discharge planning starts the minute you walk into a treatment program, because it's our absolute expectation that our providers are going to be able to connect you to the next level of care, hopefully in a completely seamless manner. So the next topic, medications.
Yeah.
Oh, one thing I did want to point out, family visits. So just...
You mean like treating the family?
Yes.
For the person who's in treatment themselves?
Yes.
Do they need to have an addiction?
No.
You can treat them?
Yes.
The law protects that.
20 visits. Provided, well, so the insurance company allows for 20 family visits
whether or
when
not
they're
they have
covered
a
under the
substance
policy,
use disorder.
whether or not they have a substance use disorder.
Because
Absolutely.
it's a family disease and we want the families to get better while the loved one's getting better.
Absolutely.
And our providers, by the way, ought to offer you that benefit.
Absolutely.
All of them, right?
Mm-hmm.
Okay.
Yep. Finally, medication. So there could potentially be a difference in the future. We're not sure, but for right now, there is currently no prior authorization for a 5-day emergency supply of medication for maintenance or detox medications for a substance use disorder, and then also access to opioid overdose reversal medication. So that would be naloxone. One tip that we say is to have the prescriber write emergency on the prescription so that they are aware that this would fall under the 5-day emergency supply.
And actually, as T was sort of hinting at, the governor's 1920 budget proposal, we want to bring parity for medication access to what we've brought for bedded and outpatient program. And we want the rule in New York to be whatever you might need, bedded treatment, outpatient treatment, or medication-assisted treatment, that you can get all of it without any prior auth or interference. So there is a proposal in this year's budget to eliminate the 5-day rule, because we would eliminate prior authorization for the appropriate forms of medication-assisted treatment. That already is the rule in Medicaid.
What about in the emergency room if someone goes in through the ER?
Different.
Different, okay.
Yeah.
That would be more, I believe that would fall more under the emergency provisions or coverage for emergency services. And there is currently in law a prudent layperson standard for whether or not emergency services are covered, and emergency services are required to be covered, I believe, under all contracts in New York State for insurance.
Okay.
So mental health coverage, you know, we've talked a lot about addiction, and parity covers both. So are there rules in New York for mental health or any kind of protections above parity?
So New York was really progressive, actually. We passed Timothy's Law, I believe, in 2006, maybe, which essentially set almost a standard for parity. I will say that we have some work to do on the coverage of mental health services, and actually as part of this year's budget, Governor Cuomo has put forward a proposal to increase access. So that includes slightly altering the definition for mental health to reference the DSM-5, the most current version of the DSM-5, and making it a little bit broader. Currently, the language only speaks to biologically based mental illness, so this would just allow for broader coverage. It includes a couple of new types of practitioners. I think nurse practitioners is one of them, so it expands the universe of people that you could have access to for mental health treatment. And we also added some state level parity provisions to New York state law to ensure that you have a clear understanding of the network and you have access to enough information as a consumer so you can really decide whether or not your policy is going to cover.
So we're trying to write parity protections into New York state law just in case. I mean, we know our federal government's very stable and functions at a great level, and so, but just in case they don't, we're trying to build those protections into our own law.
Yep.
You don't have to comment. And Timothy's Law, just so people understand, I mean, it was named after Timothy O'Clair, who took his own life. He had a history of mental illness. He couldn't get access to treatment, and he felt like that was his only choice. But it was really limited to a certain specific group. But it preceded everything. It preceded the federal parity, and it was one of the first attempts to create some minimal set of protections. It was limited to a few like biologically based mental health issues. In the governor's budget proposal, as T talked about, we are seeking to update that with the current understanding of the rule as it relates to mental health. So in-network, out-of-network, we've been talking about that. What does that really mean?
Okay, so insurance companies have requirements that they have to follow about having essentially a minimum number of providers in the area where the consumer lives. For instance, I'm going to use a not healthcare related example. I live locally, so I have access to probably 12 different grocery stores. I have an aunt who lives in the mountains and has access to one about 60 minutes away. So same thing here, right? When you buy a policy, insurance companies just have to make sure that you have access to providers or have a network of providers, people who have agreed to provide services to insurance companies' consumers or covered lives. At a specific level. So one of the standards is 30 minutes, 30 miles. So you have to be able to access services within that time frame. So if a provider is more than 30 minutes away, it's probably not an adequate network, or 30 miles away.
Now the federal parity law, that's what requires this adequate network?
So federal parity, again, is a floor, and it just requires that the network that they have and the process for adding providers into a network on the behavioral health side is the same, or at least not more restrictive or onerous than it would be on the SUD or the medical surgical side.
But as we talked about, a network provider has agreed, they have a contract with the insurance company, and they've agreed to the services they'll cover and provide and the rates they'll be paid for doing that.
Exactly.
So what's out of network? And
anything that's not in network. No. So out of network would be a facility or a provider that does not have an agreement with your insurance company prior to you showing up at their door saying, I will treat any of the people that you cover. You know, we used the example earlier, we referenced Arizona.
Right.
There are laws in place that provide for coverage of out-of-network or standards when there's coverage for out-of-network. Not every policy has to provide out-of-network benefits.
So so there you go right there. So first off, you don't just have an automatic right to go anywhere if you have private insurance, and you might not even have the benefit of being able to go to an out-of-network where they'll pay any part of that cost.
Yep.
How do you know, though, if you have out-of-network or in-network services?
So again, your contract is going to very clearly state whether or not you have out-of-network benefits. And I will note that the contract language that you see for an in-state policy, for a New York State regulated policy, New York State has something called model contract language, and this is actually applicable to both Medicaid and commercial. If you look on the Department of Financial Services website, you know, there's different language depending on if you're talking about like a small group policy or a large group policy, but it's pretty standard language, and the state actually looks at that language. So if you want to understand or see maybe a sample of what likely should be covered and generally what the language would look like, you can find it.
Okay.
Okay, so this is a lot of information, and it kind of gets at what we were talking about before. Am I entitled to out-of-network benefits? The first question you have to ask is, does my policy even provide for coverage for out-of-network services? So if you get past that, yes, great. Do they cover behavioral health services? Great, if that's a yes. Then you have to try and in the event that you do need to go out-of-network, and you know, we recognize that there is that possibility. Remember that the rules are different, so there's likely going to be prior authorization. What you should always do is reach out to your insurance company first and find out what your benefits are and ask them about in-network providers. If you can't get access to that, then ask them to help you navigate the out-of-network process. Insurance companies do have to provide you with information, so just be aware that they can help you.
But with out-of-network, if it's covered, there's different kinds of copays, which is part of your contract.
Absolutely.
They're not subject to a lot of the rules we're talking about or the protections that we've afforded. So you really need to be careful. And not to complicate too much, but there are providers within New York who will not be in every provider's network. So you could even stay within state and still have it be an out-of-network situation. That I'll give an OASAS commercial. The one thing I would say as it relates to that is any provider providing SUD treatment services in New York State is licensed by our agency and overseen by our agency, and we have a minimal set of expectations and plenty of enforcement tools to make sure that those are followed. Okay, great.
So if your insurance company won't cover care at an out-of-network facility, one of the key things that you need to be thinking about when you're seeking coverage for an out-of-network program or facility in state or what have you, you need to think about the justification for why you're going there. Obviously, if your insurance company already has a network of ready, willing, and able providers, there's got to be something that differentiates the out-of-network program to justify going there. So that's the hill you're going to have to climb, so to speak, if you're going through that process. And then you may have to get a bill from your provider and then submit it to the insurance company. It's an entirely different claiming process.
So they could even ask you to pay up front.
Yes, absolutely.
And you get reimbursed by your insurer, so you might be out of pocket. And there's no controls on the price because there's no contract.
Exactly.
What if you have, though, and I'm going back to the parity piece, if you have a bunch of, heart doctors in your area, in network, but you don't have, a number of, let's say you only have one, provider in network, what happens with that?
So I think that would be a circumstance where you could use a justification for why it would be appropriate for you to go out of network because it's an insufficient network. Say they can't get you in for 2 weeks and you've just overdosed 4 times in a week. That's a pretty severe circumstance, and that's a pretty solid justification for the immediacy of the need to get access to treatment. So, that's an indicator for the discussion that you would have with the insurance company. So we could
use that as a reason to fight a denial. Oh, that's great.
Yeah. Yep. So Tricia, we talked about utilization review. What does that mean?
Okay, so utilization review simply means that your insurance company is trying to determine whether or not you need or should have received a service. So there's a couple of different ways that they can do utilization review. For SUD specifically, when you're talking about determining an appropriate level of care, we in New York State have designated a specific tool that insurance companies have to use, that our providers have to use, and it is called lovingly Locator, or the Level of Care for Alcohol and Drug Treatment Referral. We have a very pretty graph shortly after this that you can see, but essentially this is a decision tree. It's a web-based tool that allows a clinician to assess where somebody should be when they come in seeking treatment.
And I would just point out with that, so to give you sort of a historical, quick history, in 2014 when we started enacting laws to try to address access issues in the midst of an opioid epidemic, we started with, we didn't have a tool, we didn't have Locator, we were just starting to create Locator, but what we said is we had a great concern based on what we were hearing from families about the tools that were being used, which we weren't able to look at. So we wrote into state law, OASAS, our commissioner would get to look at all the tools used by covered policies to make level of care decisions, and we had to approve them. And it was a very enlightening experience. There's concept of fail first, where insurers would say you have to fail first at outpatient before you go to a bedded program. We found, level of care tools that you had to fail 5 or 6 times before you could get a bedded program. All kinds of other very fascinating things. We evolved to a point in 2016 where we had already tested Locator, we knew it worked. And by the way, it's a web-based tool. It takes like 5 to 8 minutes to make a decision. Everybody uses it. It is, I think, transformed the conversation in many ways. It's made it a lot quicker. But now we moved in 14 to just looking at everything. Now we make everybody use Locator. Medicaid insurance companies, Medicaid managed care plans, private insurers, our providers. And then for mental health, the governor's budget this year is going to start OMH where we started in 2014. They don't have a Locator tool, but they want to see the tools that are being used and they want to approve them because they are convinced, like we were, and it bared out, that these tools are so fundamentally critical to accessing treatment, they ought to be fair and clinically sound. So we'd like to say at the beginning, we didn't have a fail first tool, we had a succeed first. You succeed where you go, or you go where we believe you'll best succeed. Doesn't mean you would get high levels of care automatically. You'd get what you needed based on a fair assessment.
To kind of build off that, I think at the end of the day, what we did when we moved to designating a specific tool is we made a universal language. Everybody was speaking the same language. Before, when you were a provider, you had 6, 7, 8, 12 different tools that you had to use depending on the patient that came in. It kind of reminds me, I remember being a kid and going to a doctor and they asked my mom what insurance company I had so they could use the appropriate Q-tip. But that it kind of changed the conversation for our providers because they were no longer having to pick between which different tool they had to use. It's all just one. So
it's standardized.
Standardized, exactly. Smoother.
Yeah.
Right?
Well, the other thing people should know with Locator as well is it's housed in the health commerce system, which is part of the DOH electronic platform. We have every use of Locator. It's contained in that database, so we look occasionally. We need to make sure that the tool is valid and remains valid, but we can also make sure whether the tool is being used efficiently and appropriately.
And is it used more than once?
So Locator is used initially to determine whether or not somebody is appropriate for that level of care, but we also have what's called the continuing care module, which is the tool that our clinicians can use to essentially assess whether or not a person needs to continue to stay in that level of care.
Oh, cool.
Great.
So a couple of, we've already covered all of these. Yep. So a couple of just distinctions between different types of utilization review. The first is pre-authorization or prior authorization. So this happens before you get a service. Concurrent review is while you're receiving the service. Retrospective review is after you've left treatment, the insurance company will go back and look at the entire service provided to determine all or what part in whole or in part is clinically appropriate. Formulary exceptions and step therapy overrides are actually something I wanted to hit on. So a formulary exception, a formulary is a list of medications that your insurance company has said, we are going to cover these medications, and they will determine, they'll set standards for if you need to talk to them before you can have the medication. Usually your pharmacy will do the prior authorizations, and when you get there and pick up the medication, they've already conducted all the prior auth. Or they'll set limits. You can only have 30 pills, you can only have 30 days worth or 90 days, you know, whatever standards they choose to set. But there is a process, a formulary exception process, that allows you to request the ability to use some medication that is not on their formulary. So I just wanted to flag that because I think that's really relevant for our population.
So buprenorphine, which is one of the medications, one of the 3 approved for treating opioid use disorder.
Yep.
There are multiple versions of buprenorphine. I will not name any of them because I don't do any advertising for pharmaceutical companies. But we are aware of circumstances where they may be on buprenorphine version A, and the company covers version B, but the person's stable on version A, so their doctor could use that exception process to say, my client is doing well on A, I would like him to remain on A.
Exactly.
And that's the process.
Yep.
That's what that means.
And if the doctor notes that there is an immediacy or an emergency to, making this determination, then it's expedited or it's a quicker process. Now the step therapy override, that's a little different. So that just means that the insurance company has a formulary and there's tiers. So there's preferred medications, so tier 1, and then tier 2 would be medications that they cover, but they want you to try medication A first before you do B. Step therapy override process allows you to get to medication B without having to try medication A. Perhaps there is something in medication A you're allergic to, or you've reacted poorly to it, so medication B really is more appropriate.
So a really important piece there, and a plug for our sister agency, the Department of Financial Services. So that everyone understands another benefit of a New York State covered insurance policy. No insurer in New York can just issue a policy. It needs to be approved by the Department of Financial Services, and that's why they create model contract language. They say to you, as you're writing your contract for our review and approval, here are certain elements that absolutely must be in your contract. And they do allow for the tiering of drugs. Another component of their oversight is they issue what's called circular letters, which are guidance, regulatory documents that the insurance companies need to follow in order to get an approved product issued in New York State. And they've recently said that, yes, you can tier products, but as it relates to products for addiction and substance use disorder, you can't set the products up and tier them based on price alone. There have to be other considerations, clinical justifications to make those kinds of decisions.
Yep.
Great. I mean, I think we've already covered this in terms of what locator is. Like I said, what we ultimately decided is the safest way of getting to where we needed to get to, which was quick, clinically sound decisions, was, we're New York. We do our own thing. So there are other tools that are out there. We don't disparage any of those. We got to where we got to. Our tool was written by clinicians. It's reviewed frequently by clinicians. Web-based, you don't need to be a doctor to use it, but it guides you through a series of questions which leads to a quick decision about the most appropriate place for someone to get care. So, and that's actually
Yeah, so those are the different aspects of the locator. This is what they're looking at. So initially just putting in patient identifying information, they do a preliminary assessment, and then they look at, you know, is the person in crisis? What are the resources and the risks that you have? Has the person had repeated overdoses in the last week? Are they living in a home where there are others who are using? Do they have a supportive family environment? You know, so it's just a kind of flow chart of what they're looking at and how they're getting to the decision.
And actually that's a really good, I talked about success driven. Here's what I meant. So as you're going through this process with the locator, and you know, the person's at a bedded program, but then you go through it and you determine A, they have a job or they're going to school. They have a supportive environment. There isn't other drug use. They have a place to live. They're stably housed, stably fed. They have all the elements in place for them to succeed, excuse me, in a lower level of care. So they would be appropriate to go to an outpatient versus a bedded program. So there is no default that everyone ends up in a bed to start. The default is the place where you will most likely succeed in treatment is the place that you would be sent.
It's not a one-size-fits-all.
No.
It's a really individualized, patient-centered, person-centered.
Right. So you are pre-authorization. We keep saying that. What is that?
All right. So this is the process that the insurance company is going to go to determine whether or not it would be medically appropriate for you to receive the service that you're requesting before you receive it. So prior to. When you're doing a prior authorization process, there are time frames that the insurance companies have to meet. So if you make a request for a service, they have to respond back in standard time of 3 days. But there are opportunities for providers or for you to explain why it's critical that you receive a response sooner. So then it would be 72 hours. Court-ordered treatment, I feel like that 72 hours is not right.
But the most important things about pre-authorization.
Oh, 3 business days,
right.
I think is what it is. Yes.
But if you are, as we talked, so these really are more relevant if you are using a non-covered, non-New York State covered policy.
If it's an in-state or out-of-state,
this is the rule. This is gone. All these things we're talking about don't apply in Medicaid and don't apply in insurance policies covered by New York State law. Great.
I did want to touch on court-ordered treatment, though, because I think that's relevant. So for the commercial side of the world, there are circumstances where an individual could potentially be mandated or court-ordered to go to treatment for a period of time. Just so you are aware, there is a special form, there is a special process for you to reach out to your insurance company and say that I have a court order or I anticipate I will be getting a court order. Here is the document explaining that, and they have to make a decision about whether or not they're going to provide coverage for that court-ordered service within 72 hours. So just be mindful of that.
So concurrent review.
Yes.
What's that mean?
So I've been in treatment for a while, and then maybe in current day's world, I'm appropriate for treatment. I've been there for 14 days. Day 15, my provider and my insurance company have a discussion about whether or not it's appropriate for me to continue in care. So am I going to get additional services? There is a response time that the insurance company has to meet, so that's 1 business day. However, one thing I will say is if you are in a bedded program, we had special laws put in place, and this is actually applicable to any bedded service. If you are seeking care, more care, or looking to transition to a different level of care, they have to respond within 24 hours. If you request it, they have to respond within 24 hours. If they respond to that request and deny it, there's also an expedited time frame for them to reconsider that decision to deny. We'll actually get into that when we do the appeals process.
So bringing all these things into trying to bring everything together. So you go to an in-state OASAS in-network covered program.
Yep.
You don't have to get prior approval. You can go. There's that 48-hour notice, hey, the person's here. There is conversation that should occur. It's just they can't say to you on day 7, you need to leave. On day 14, though, they can start doing reviews to say, hey, you should no longer be there. But on day 13, if the program and the person decides they really need 20 days, they can request extension of the care beyond the 14th day. Mm-hmm. And if they get it, wonderful. We hope they should, because if they use our tool and that's what it said, that's what it ought to be. But say the insurer denies. So then these processes you're talking about, if you appeal that denial, mm-hmm. they have to cover the additional care. You stay in the program while they're deciding the appeal.
Yep, the language is that they pay during the pendency of the appeal.
And so importantly, the other protections we built in, the family's not going to be responsible for that.
Exactly.
And then that includes staying in the program or even transitioning to another program from that program. Mm-hmm. Yep. That all these protections sort of build together to protect somebody's access to care.
Yep.
Great.
So I have a real quick question. Yeah. What happens if you're in care and you're being told by the provider that you only get 7 days or you only get 14 days?
So the first question is, what kind of policy is it? That's one of the most important things that you should take away mm-hmm. from this. Is it a policy covered by New York state law that we've been talking mm-hmm. about? Is it Medicaid managed care? If you hear that, they're wrong. All these rules we've talked about, there is no 7 days. If it's a non-covered ERISA policy, one written in another state, it depends. It depends on what that contract said. And so
it's also the provider that needs to be working with the person who's in treatment to kind of help navigate some of that as well?
So we're going to get into appeals.
Okay.
But appeals can be asked for by the people in a contractual relationship with the insurer, which is the provider and the family, the person in care. Mm-hmm. Both can appeal. We know of instances where providers sometimes are reluctant to appeal, but the family can always appeal, which, as you know, which is part of why we'll talk about why you're in the mix now for some of these things, because appealing these decisions, if everyone believes it's the wrong decision, is an essential part of making sure people get access to what they're entitled to.
Awesome.
So retrospective review, what is that?
The look back. So this is the...
That's permitted?
It is permitted. An insurance company can look back to determine if care that was provided was medically appropriate. This is actually what we built in specifically with the bedded care and the outpatient care. Because there's no prior auth, we wanted to kind of balance the equities, so to speak, when we developed these laws. So a couple of things to be mindful of. Because it's care that's already been provided, it's not quite as rapid of a process when they're looking at whether or not they're going to cover services. So they don't have to respond as quickly. It's about 30 days. But the one thing that I will say is, if they make a decision and they haven't talked to the provider, then absolutely request a reconsideration, or I believe it's called a peer-to-peer review in the insurance world. So that means that a clinician from the insurance company and a clinician from the provider will speak together.
So the law is that every insurance company can do retrospective review on every episode of care provided?
So they are permitted to do retrospective review, but what I would say is, remember, we have the overarching standard, the floor, right, of parity. So I would argue that if you have an insurance company that is conducting retrospective review and requesting, significant volumes of information from a provider for every single SUD claim, and not on the medical surgical side, that there would be a question of if they're really being fair. But you mean they can't
say to the provider, so you had 20 people in your program last month, I want the full chart for all 20 people?
So the standard is that the insurance company should only be requesting additional documentation and not making a decision where the obligation to pay is not reasonably clear, I think is the language within the statute. So it cannot be a default to, I'm always going to request a whole chart, because that would not be reasonable. Presumably, a broken clock is right twice a day. There can't be there can't be every single situation is wrong.
But to the point you made, it also has to be equal to what you do. And from a parity perspective, whatever you do for medical health, for medical surgical, you can do no worse on the mental health and addiction side.
Exactly.
Okay.
That's the measurement. Okay.
That's the
So-
starting measurement.
That's the starting measurement.
Yes.
Okay.
So we've talked a lot about medications and
Yeah.
opioid use disorder. There are 3 medications, by the way, that are the gold standard of treating opioid use disorder and should be always, in our opinion, be the first course of treatment. There's methadone, buprenorphine, and there's injectable long-acting naltrexone, or Vivitrol, I think is the product name, because there's only one product. So, so what are there there are a lot of rules. They're expensive
so-
medications. They work, but they can be expensive.
They can be, yep. So this actually just speaks to, we talked about a little bit earlier, the tiering, so different levels, and is kind of just a flag, really. So if you are on a medication, just be mindful that insurance companies do change tiers from time to time, or shift drugs from maybe, tier A to tier B, but they have to tell you first. They can't just surprise you. Typically, you'll get something in the mail, so I would strongly encourage you to open letters from your insurance company
Can
so
they
you don't
do
get that
something
surprise.
like that, like in the middle of your contract?
No, because you've signed a contract, right? You've
So
agreed
they're
to a
bound
term.
just as you're bound for that term of that contract. So it's like on a year to year.
Mm-hmm.
But so those notices you get about your insurance being continued,
Yes.
you
Double
should
check
read
it.
those.
Yes, very
Because they
important.
point out the changes they're making.
Yes, exactly. And that also gets at the formulary exception process. So say you have medication A and you know what, next year we're not going to cover it. Or maybe the brand name got more expensive. You know,
Yeah.
that's a relevant hot topic nowadays. It could be shifted to a higher tier or maybe removed from the formulary in its entirety. So just be mindful that if that does happen, you have an ability to pursue an exception process and have
one
access
sort
to
of
that
key
medication.
override point here is these laws are important, but as important is the agreement that you've made with your insurance company.
Mm-hmm.
Understand, we're all, well, 2 of us are lawyers, and Stephanie has no choice but to read contracts doing what she does. But they can be tedious, but that is the agreement. That is the understanding. Those are the rules for your relationship with your insurance company. And importantly, and we'll get into it a little bit, it includes all the ways you can exercise your rights. And so, and we've said this to folks, and I want to say it now, we'll probably say it down the road in this conversation. The first question you'll be asked by our Department of Financial Services if you want to complain about you didn't get covered and you should have been and they were wrong, the first question they will ask you, did you exercise your rights to appeal or to grieve under your contract? And if you answer no, they're going to say to you, there's really probably not much I can do for you, because effectively by not appealing or grieving, you accepted the decision by the terms of your contract. Is that a fair?
That is absolutely a very incredibly important point.
Great.
Okay, so a step therapy protocol, that just means that the sequence you get access to medications and formulary exception. We really already touched on this one. Okay.
So appeals.
Appeals. Everybody loves appeals. Is a favorite topic. next to
Lawyers
medical
love
necessity.
appeals.
Yeah, they're great.
We'd prefer nobody appeal in this world, but that's a whole different conversation. We'd prefer nobody have to. How about
Yes,
that?
that's more accurate. Okay, so essentially an appeal happens when an insurance company has conducted some sort of utilization review, so prior, concurrent, retrospective, or something with the medications, and said, no, you don't need this service. So your first step after being like, what do you mean? Is to say, no, I want you to reconsider. So that's what an appeal is. It's asking them to look at their decision again and decide, hopefully in your favor, though that is not always the case. There's two different types to be aware of. So the first is internal. So that's where the insurance company has somebody within their universe look at the claim and all the documents that they have and decide whether or not they're going to allow to say yes, or so overturn, say yes, or keep the decision that they made. And then external, that's where somebody who's not associated with the insurance company, it's an external entity, it's somebody who is selected by the Department of Financial Services, and you actually file your external appeal with the Department of Financial Services. They hire essentially the external appeal agents. They look at all of the information and decide whether or not the care should have been covered.
So in that instance, they're going to hire an expert. So you can't use a gynecologist to make a decision about addiction treatment?
No. We have provisions in the law for utilization review, and also when you're on the internal and external appeals processes, that the person making the decision has to know something about SUD. So either it's going to be a
that would
physician.
make them an expert?
Well,
Yeah, okay. I'm just...
they should
But it's
know.
an important,
Yes.
but even those are the kinds of things you need to look at. Who's doing the review?
Exactly, and looking at what tools they're using to
Right.
do the review. You know, one of the things you'll see if you're looking at an external appeal decision is the materials that they use to make the decision. So
Right.
if you look at the materials they use to make the decision and locator's not in there, but ASAM is, that's a question that you need to ask, and that is something you need to pursue because they shouldn't be using just ASAM.
Just a quick anecdote on appeal. So when we, in 2014, started enacting some of the new protections that we did in New York, we were being told by the insurance companies, well, we win 80% of appeals. So then I said, well, my nature, by the way, is I'm inquisitive, I think is the politest way people have described it. So I said, okay, so is that all appeals? Well, no, that's external. I said, so let's take a sample of 10 cases. On the internal, how many are decided which way? Well, on the internal appeals, out of 10, 5 are decided in favor of each. So there's 5 where the person who was denied has now been approved. So I said, it's okay, so there's 5 left. So 80% of those 5, the insurance company wins. I said, yes, exactly. I said, so 5 plus 1 is 6. So 60% of appeals are decided in the insured's, the patient's, favor. They said, yes, 80%. So there's the new math of the insurance world. I'm sorry I had to say that. So here we go. So we talked about who can request,
Yep.
who the person needs to be.
Quick question, can you
Yep.
can you have both the provider doing the appeal and the family member?
I mean, there's nothing that says that they can't.
Okay.
You know,
We would
I
certainly
think,
hope they're working together.
yeah, I would definitely think that it would be better if they were working in coordination with each other, because obviously the program has a lot of the clinical information, and the insurance company is going to be looking for a clinical or medical justification for why the service is appropriate. And the provider is going to be the expert in that.
And
right?
the one thing I'd point out to just sort of amplify on that, if you're in one of our programs and in the moment your provider is saying, I'm unwilling to appeal, look us up. You can find us. You should come and contact us, because we would want to have a conversation as to why that's the case. Because we're talking about appeals, so that means the provider said, I believe they need more help. And it was denied, and that leads to the appeals process, but why aren't they willing to appeal? And that, ultimately leads into the ombuds program. But it's really critical. If you are denied and you don't appeal, you've effectively accepted the decision that was made.
Yep.
And you have no rights to grieve it subsequent.
Exactly.
Internal, we've talked about the different kinds of what they are.
So these are just timeframes that
Yeah.
you have to, that the insurance company has to hit. But I would also note that in your insurance contract, it's going to tell you how long you have in order to ask them to reconsider something. And the other thing I will say is for substance use disorder services, we have a really expedited time frame for when the insurance company is supposed to make a decision. But through all of these, there is an expectation that whoever is submitting the information get it to the insurance company in a timely fashion. Otherwise, they aren't subject to those timeframes, because they only have to make those decisions because within that time frame, within receipt
So
of this
that's a really
information.
good point. So these expedited processes, which we put into place because somebody in crisis from addiction needs immediate decisions, they have to have the information to make the decision. So if you don't provide the information, they can delay the process because you've not followed the steps you needed to follow to accelerate it.
Yep.
It's external. We've talked about the external appeals. I don't know if there's any piece.
Just one thing to be mindful of for the formulary exception process, there's, I mentioned it before, but there's also an expedited process for the external. Same with inpatient SUD services. The external process is an expedited process. And again, getting the paperwork in within the appropriate timeframes, making the request 24 hours prior to discharge, that's all really, really important to hit those timeframes and be responsive, because that's what's going to entitle you to those protections.
So you, just real quick question, so for the internal and external, do you do the both of them
At the same time?
at the same time?
could.
So you could. The first, when you're talking about internal appeals, there's a process you have to go to. So the first step is what's called a peer-to-peer review. So that's where program doc and insurance doc or other clinician will talk, and they'll either agree or you know, in the sad circumstances where they disagree, that's where you say, okay, I want an internal appeal. So it goes to the official appeal process that they have to follow, the timeframes they have to meet. And then the outcome of that, that's called a final adverse determination. And that's what entitles you to go to an external appeal and ask for the state designated entity to look at it with fresh eyes. But there are timeframes where you can talk with the insurance company and say, I would like to also pursue an external appeal, and you can do both kind of in tandem.
But what if you have a loved one and they're in treatment and the provider is saying that they're being denied additional treatment? Like, can they appeal and stay there, or do they have to leave, or how
That's
does
why
that
we
work?
talked about, we built those protections into the law.
When you're in bedded treatment and you've met the 24-hour time frame, so you're doing the expedited appeals process, the rule is that the insurance company has to pay for that care while the entire process is being played out, both internal and external. So the initial decision is within 24 hours, and then the internal appeal, I believe, is 24 hours, and then the external is 72 hours, provided everybody meets those timeframes. I think it works out to like 6
And what
days,
that's
maybe, but
done, the law, what
pay
it
for it.
has done, a lot of times, one of the insurer in many instances will say, well, let's avoid the internal appeal and just go immediately to an external appeal. But because we try, again, we wanted to build these sort of balancing of equities in, but the most important piece, because what occurred prior to these laws is the following. Well, you can't stay here anymore, or what was worse, they'd call OASAS and say, well, you need to keep them, Mr. Provider. So the provider would not get paid for providing care, or the person would be asked to leave if we didn't know about it. It's just totally unacceptable. Providers not getting paid and people not getting the care they need. That's why we built these protections into New York state law. At some point, by the way, I hope they'd be built into the ERISA covered federal plans. Why are we still being denied? We still hear this, so who wants to take this one on?
Well, I know that there's been a history of discrimination in the substance use world and the mental health world, right? And so there were some studies that were done, I believe it was in 2015, the Millman study was done, in which it was determined that folks that had, you know, who were in need of substance use or mental health issue had to go out of network for care much more than the folks who were on the medical surgical side. So, and then interestingly enough, providers were paid less than on the medical surgical side. So not only are you, in terms of being a consumer, that you're, you know, looking at, you know, stigma and discrimination, but if you're a provider, similarly, your rates of reimbursement are going to be different. And those disparities only got worse. And I know that there were a number of cases that were determined by the New York Attorney General at the time, Schneiderman, I believe, who decided that you know, there was some widespread parity violations.
Okay. So commercial versus Medicaid, because because the parity reviews have been looking at both commercial insurance and Medicaid, because Medicaid is also subject. If you didn't understand that, Medicaid is subject to the parity law.
Yes, and it used to be that Medicaid, correct me if I'm wrong, but Medicaid was, people didn't want to use Medicaid. It was denied. The, providers didn't get reimbursed for Medicaid. And then all of a sudden there was all of this legal work that was done by these people in the Office of Alcoholism and Substance Abuse Services that started creating, wrecking havoc for those folks, and actually redesigned essentially the payment structure, right? So that was great. So then Medicaid got reimbursed, but then there were a couple of studies, the Kaiser study and the Weissman study that were done that showed that on the commercial end, there were these incredible disparities. And in fact, for those of us who have fabulous commercial insurance, still there are, when we try to get services for substance use or mental health, still there's some pretty egregious disparities in terms of what's covered. And there's data that suggests that, this is in line with, as the epidemics exponentially rose, right? That these areas, these denials mysteriously also occurred, right? So, it really, there was this need then for consumers and providers to understand what their rights were, and then how to, proceed with getting those rights addressed.
So the solution, oh, look at that. So we've been active. We're active in New York. So do you guys want to go through some of the history? We've talked a little bit as we've been going through this of things we've done in New York to create protections that I dare say most other states don't have.
Well, I know, and prior to my coming here and working with you fine folk, I was an advocate for in the substance use world, and I would go to national conferences, and other states would say, you guys have the Timothy's Law, and you guys have, well, we had the Affordable Care Act and the Mental Health Parity and Addiction Act. Right. But then there were all these laws in New York State that happened to address the opioid crisis. In 2014, there were a number of laws. And then in 2016, we were fighting really hard for an end to prior auth and for better treatment, as well as to get access, right, to medications. And then for this locator tool to be utilized. The sad thing is that even with all of these incredible advances that have been made legislatively and regulation, there's still so few people who really understand what parity is. And it's complex, isn't it?
Oh, yeah.
So, and we've talked about parity. I mean, literally, it's parity. It means that however you treat medical surgical benefits, you can treat or you can't treat the mental health and substance use benefits any differently or any worse.
And I think the key too is that folks think that just because they should, right? But I think your point that it has to be on par, and you said the same thing, T, that it has to be on par, and that's where reading the plan, reading the contract is so important. Right,
and it's also why that means you can be down here. We in New York have tried to go up here with the rules. We exceed parity in almost every single way. Or if anything, what I think is probably going to become the case is we spend more effort on looking at parity compliance. We've brought through our laws the world where it should have been to comply with parity. And that's one of the things, and that's one of the things we're going to focus on moving forward. It is great to say you have a law, but if you aren't able to ensure that people are following it, it is a wonderful document with words on a piece of paper, and it has no meaning, it has no value. So, so parity is one of the areas that we're going to focus on moving forward. So we've enacted all these laws, we've gone through them. And we've said frequently as we go out and talk that if the laws aren't followed, they have no value, no meaning. One of the things we had tried to do for a number of years is to create sort of that backstop, that protector, the person or group of people who make sure that these laws are followed, that people get access to mental health and addiction treatment. And we are government, so acronyms are our lifeblood. So in 2018, the governor's budget contained money to create an ombudsman program, and we couldn't leave it there, so we gave it its own name called CHAMP, and our champ is Stephanie. And so what does CHAMP mean, Stephanie?
Well, again, to your point, in 2018, we really advocated strongly for this, and we wanted to have this independent ombudsman program, and also to be working in collaboration with our friends over at OMH. I know that both you and Emil over at OMH are doing an incredible job at that collaboration piece. And it's and so we contracted out with an organization called the Community Service Society. We're also working with Legal Action Center, which has been doing just a history, an incredible history of advocacy for our population, as well as the New York State Council for Community Behavioral Health Care, and to run this program. And I sort of oversee CHAMP.
So what is CHAMP? Here we go. Here's the program
so
name.
it's the Community Health Access to Addiction and Mental Health Care Project. To your point, we love acronyms. CHAMP is under again, CSS's administrative helpline. So it's the third choice when you call this number, 888-614-5400. Right. There is a wide range of options that you can access. But if you need specific help with substance use or mental health care, you would hit the third option, and with insurance, and we would be able to connect you to someone who would be able to walk you through that process.
And that email that's listed goes to you?
Yes, that goes directly to me. I look at it regularly on a daily basis, and so it is ombuds@oasas.ny.gov. I am the Ombudsman Project Director. Some folks like to call me the Ombudswoman Project Director, or just the Ombuds. It really doesn't matter. What does matter is that folks know that that they have that help is available.
So, and this is a flyer we've
created? There's a one-pager that we've circulated. It's up on our website. OMH also has put it up on their website. Any of the specialists, we call it the five-legged stool. So we've got CSS, we've got the Legal Action Center, the Legal Aid Society, as well as Medicare Rights Center. They all have access to this one-pager as well as the brochure. And now we have some additional CBOs, community-based organizations, that also are disseminating this information.
And this is a project we're going to continue in perpetuity, hopefully.
Absolutely.
So why would I call this phone number? What would be the reason that I would call this number?
Yeah, so you would call this number if you needed access. Well, first of all, it's an educational number too. Let's say, for example, in all of the amazing information that T provided, that you have no idea of how to navigate this whole world. It's very complicated. You can call the number and say, hey, this is my insurance plan. I'm not sure if my loved one has, has access to this kind of care. Can you help me understand it? So it's a way to, know your rights. But it's also, if there are barriers that you're finding, in trying to access care, call the 188. Remember Crazy Eddie? Remember I'm hoping that people, get this number embedded in their brains, 888-614-5400. But you could call that number and say to the person on the phone, listen, I'm just they're telling me something, it doesn't make any sense to me. Can you help me get around, some of what's happening, help me understand what they're saying to me.
So it might be two purposes, though, or at least two, but one could be, I can't find a place.
Yes.
Or I found a place and they're saying, no, I can't go there.
That's right. That's right.
And we try to help them in either instance. Find the place and make sure they can get through the front door.
That's right. Or that they're being told that they're going to be kicked out of the place.
So it's an important new tool that we've added. We believe that these are the kinds of things that we would do to make sure the laws that we've enacted are followed, which gives them their meaning. So we also love FAQs, so we've added a few in to just try to help people understand. So can the insurer, we actually already did this, ask for all patient records every time?
No.
And T?
No, it has to be
They
reasonable.
can't?
No.
Do they? Don't answer.
Not every time, I'm sure there's one.
Just so everyone understands, what that means is, and we've seen it, which is why I made the smart comment that I made, they can't say, like I mentioned, in all 20 cases, what we used as an example, I want your full chart sent to me so I can do a review to see if the care was needed. Mm-hmm. They should have a bunch of it already. Mm-hmm. And it doesn't mean that they couldn't look at every record on some level and request a full chart maybe here or there. Reasonable was the word you used.
Exactly.
So, am I only allowed 14 days of treatment? I think I may have beat that one up, and I think the guys, I didn't create the PowerPoint slide, but it's
I did that one.
not enough no's. But one of the other important points I hope you would take, if your policy is covered by New York state law, you are entitled to the care that you need. It could be 4 days, it could be 29 days, it could be 14 days. There is no rule in New York that says everybody's only entitled to 14 days. So if you hear that, tell them Rob Kent said you're wrong, because you are. You get what you need. And you get what you need place by place. So as T said, the rules restart every program you move to. Mm-hmm. It's not one set of 14 days. Mm-hmm. So for instance, you could go to detox for a few days.
Yep.
And you could be then moved to a residential or inpatient program. The clock starts again. Mm-hmm. Okay. We can't admit you because you're on Suboxone. So I think you guys put this in on purpose. So in the midst of an opioid epidemic, where medications are clearly the frontline treatment for treating opioid use disorder, you can never get somebody to start working on themselves until you can get them physically in a place where they can actually think and work on themselves. So, and in the midst of this opioid epidemic, we've heard it frequently, well, we're an abstinence-based only program, and that is not legal, said the counsel for the state agency that oversees those programs. Every one of our programs must make medication-assisted treatment available within their building or with a relationship with another provider or organization. So it must be made available. And no provider should be saying to you, you can't come to me because you're on buprenorphine or methadone, or absolutely impermissible. And I say that and I mean it, and I can tell you I've gotten calls from families. My son is on buprenorphine. This program is saying they can't take him because he's on buprenorphine. Interventions are one of the things that occurs in our world. So I do my own form of intervention. It usually involves dollar signs and the word fine. This is not permissible. We are losing in New York State, best set of information, about 3,000 people a year to drug overdose, many of them for opioid overdose. You cannot deny people access to medication-assisted treatment and expect those numbers to ever decline. So you've heard it here. You can find documents all over our webpage. You can find new rules that we've published. Every OASAS licensed program must make medication-assisted treatment available. Every one of them has to allow anyone who is already on medication-assisted treatment to enter their program. If any of you hear the opposite, you should reach out to my staff and we'll yet again do another intervention. That is not permissible, it is not the rule, it is not the law, and it's not the right thing to do. So Stephanie, maybe you want to take this one. Your child does not need to be in a hospital. Have we heard that before?
We certainly have, and you know, the question would really be, so, you know, how are you determining this? You know, what's the tool that you're using? If your child needs medication, you know, are you able to give them the medication that they need? Just like with any other chronic illness, we want to be able to have standards of care in which people are getting assessed in the way that they need to. Also, we have family members who are desperate and saying, well, you know, can you help me if I can't get my child into a hospital, or if I can't get this, can you help with continuing care? Can you assist me with, you know, other resources? And so we want to encourage folks to, you know, to know that those connections need to be made, and that their kids do have access to medication, and that the tools that those who are doing the assessments are.
And two pieces related to this. One is we worked out a sort of statement of policy from our agency and from the State Department of Health, which oversees all hospitals. And we made it abundantly clear that any bed in any hospital can be used to detox somebody. That is the rule. It's on our webpage. You can find it. That is a document that was signed by me and one of my colleagues at the Department of Health, who oversees the part of the Department of Health that regulates hospitals. So any bed could be used. Another thing we're really focused on, what about MAT, medication-assisted treatment? And this year's budget includes some provisions to really enhance this effort. So many people in crisis and have overdosed or clearly, you know, in need of addiction help, in many instances in need of medication-assisted treatment, go through emergency rooms. For far too often, they were quote-unquote stabilized and allowed to leave. For those who don't know, if you overdose and you're reversed by Narcan, wonderful thing. You have induced that person into immediate withdrawal. You've taken their high away. So if you let that person leave the emergency room without some type of intervention, they are in withdrawal. I can tell you what they do because we've seen it far too often. They will go find the drugs they were using and start using again. And the worst part is that a person who has been reversed, their tolerance has been thoroughly disrupted. So if they use at the same level, they're not tolerating at that same level. They are even more likely to overdose and even that much more likely to die as a result.
Yeah.
So we want buprenorphine to be offered in emergency departments, in every emergency department in the state. And I say that with the comfort that that comes right from the governor. He's told us that ought to be the standard of care in every hospital emergency department in New York State. And that is part of his budget this year, which we hope in a future conversation we can say it's now the law in New York State. There are many hospitals that are already doing it. It ought to be the rule every place. So what is this ED or ER survival guide? So
when I was in my previous role as the executive director, we would have advocates from around the state who would call. I would have phone calls from people saying, I'm at the emergency room, they're telling me that my kid has to leave, they can't do anything for them. And so you and I and some advocates had a conversation, and you and Mr. Shepard from DOH put together this letter. Now I can tell you that very shortly after that letter was created, I got a call from a mother who was desperate. Her child was in the ER. I was close enough to bring another advocate with me. We showed up. She was being told, no, we can't do anything. Your son has to be discharged. We actually used the letter right there to say to, and we advocated on behalf of this child, here's this letter that, that OASAS and DOH put together. You're covered, you know, there's a waiver, and we were fortunate enough to have a hospital person there who was willing to do this.
And you turned to staff in that, because I know of the situation.
Yeah.
You turned the doctor and the nurse into advocates with you.
Absolutely. And we
so
were
you
able
armed
to
them
keep
within their own administration.
Absolutely, absolutely. And we were able to keep him there in the hospital for a while until we were then able to link him up to a treatment facility that could take him. We knew that the concern was that if he was let go, because he had overdosed, not once, not twice, but several times, that he was at high risk, to your point, because he had been reversed, he would die. And this has happened on any number of occasions. So anyway, we decided at For New York to collaborate with our friends at Greater Monroe Recovery Community Organization, our friends at Friends of Recovery Albany, as well as some other advocates. We put together this survival guide to hand out to parents and to family members so that when they went to the hospital, they had sort of a checklist. You know, there was the Attorney General office's hotline number. There was OASIS's Pick-em number that was on there, as well as the combat addiction linkage. So there are a number of resources on that guide. If folks are really interested in getting access to that, I would encourage them to contact Friends of Recovery New York, and you can get
it's on their
that
homepage.
document. Yes.
And if I may, one of the things that we didn't mention yet, which I think is really important, is when you are in the emergency department and you or your child, somebody you know, has overdosed, specific to the medication, doctors don't need any additional federal authority to prescribe or to administer buprenorphine. There's actually an exception in federal law which allows a doctor to give a patient buprenorphine directly while they're in the hospital, and they can do that once a day for 3 days. So that gives an opportunity, if you really work with the hospital, to stabilize the patient. That gives you a chance to find a treatment program. And also, another question I would absolutely ask is, do you have any connection with a peer? We've heard great stories about certified recovery peer advocates in New York who are having tremendous impact with individuals who've been in the ERs who've recently been reversed.
Right, and for those who don't understand, T's talking about buprenorphine. So, of course, we talked about stigma at the front end. So 2 of the medications I mentioned to you, methadone and buprenorphine, they're controlled substances. You can be prescribed them, by the way, for pain in any doctor or prescriber's practice anywhere in the United States of America for pain, with no limits, nothing other than the other regular limits that apply to any medication. When you use them for addiction treatment, for methadone, it can only be done by a prescriber in a state and federally regulated methadone treatment program, and it has to be stored in a safe that rivals that of Fort Knox. For buprenorphine, the doctor or prescriber needs to be federally certified, take a training course. Well, now it's doctors, nurse practitioners, and physician's assistants. They're limited in the number of people they can treat. And they're subject to pretty stringent federal oversight. So T's point is really key. There is this exception in an emergency situation where the doctor, nurse practitioner, PA don't need to have gone through that extra layer of federal oversight. So as we talk about stigma and the real life impact of stigma, there is a great example right there. So credentials, we've mentioned here and there, but there are all these names out there. So what's a CERPA or a CRPA?
So a CERPA is a Certified Recovery Peer Advocate. And this is an individual who is credentialed by the New York Certification Board, which is an entity that we've delegated our authority to. And they are someone that can work to kind of meet people where they're at. You know, a lot of the things that we've seen, we've mentioned EDs. They're a really relevant place for peers, but also out in the community to go and speak to people and work on engaging them in treatment, or maybe they've been, somebody's been in treatment and they kind of fell off a little bit. So you can send a peer into the community, they can speak with that individual, try and re-engage them. So it's really somebody to try and offer lived experiences and kind of share in the, help that person get through what
so
they're
they're in
going
recovery
through.
themselves, or
Typically.
they have a family member, so they've got lived experience with addiction issues.
Exactly.
So what's a certified addiction recovery coach?
A CARC, yeah, it's a little bit different. They're certified through another process. They're not SERPAs, I think is really important to know. And there is a certification process that they go through, but I don't believe that they can be billed through Medicaid, which the SERPAs can be.
Yeah.
And the SERPAs are connected, I believe, to OASAS licensed facilities, which the CARCs are not.
Right.
Yeah.
So CASACs, what are CASACs?
Sure. So a CASAC is a credentialed alcoholism and substance abuse counselor. So we at OASAS, we actually regulate this credential, oversee it, and grant the credential to individuals. So these are counselors who work in our programs typically, and they actually work directly with patients in a clinical function to assist them on their road to recovery when they're in treatment.
Great. And these are all folks that are relevant to all the things, all the programs, everything we've been talking about. So a note of caution, a free plane ride is not a good sign. So I'm just going to give you an example of stories we've heard about people out-of-state treatment situations. And we're very much, first off, I have to say, we believe in the programs that we license and certify, and there is available treatment in New York State every day. Every day. And a good portion of it we pay for. So we pay our providers to make treatment available for people who can't pay themselves. So understand that, but then understand this. We get plenty of examples where people will go to an out-of-state program for treatment. They use this out-of-network benefit. They might get charged for a 30-day episode of care, a couple $100,000. They pay 20 to 30%. What we've heard from the insurance companies, because they don't like this, is actually one where we're on the same page. They like it just as little as we do. But so many times, the family is calling to access their insurance in the state where that program is, because out of the goodness of these people's hearts, they paid for them to fly down there, the whole family. Beware. Those programs, by and large, don't work. And I don't want to impugn any state's programs, although I really could. I would say the following. We have on our website a Find Addiction Treatment tool. We have an Ombuds. We have T, you have me. We have all these resources now that we make available. We have a Hope Line. You can find treatment in New York State any day in many parts of this state. We stand behind that which we fund and license. I can't tell you the first thing good or bad about any other state's programs because I don't know. I can give you frequent examples of where they didn't work. And I can give you the offshoots of many of those because we've dealt with these families. They come home, they did not get better, the family's bankrupted, they borrowed against their house, they used up their retirement to pay that 20, 30% copay. We will find them help in New York State because we are in New York State. We take care of our own. God, I wish we could have prevented them from leaving in the first place and wasting a couple $100,000 in the instance. So please, access all these resources, take advantage of the rights that we've provided to you, the protections we've made available, but you should absolutely be able to find treatment. So if somebody offers you a free plane ride, be really careful about where that's going to lead you. Oh, we just have to use this. So Sam Quinones, who wrote Dreamland, which if you haven't read the book, you ought to read the book. It's about how we got where we're at as it relates to this opioid epidemic. And we saw him all speak recently at a big provider event in New York State. And he's made this comment. He made it there. He's made it and published it in so many places. So much of what we deal with and so much of what we hear from people who are suffering from addiction, it's an isolating, lonely disease. And so much of what we're experiencing with the opioid epidemic, and I would say almost every other human tragedy that we come across, is this lack of connection with each other and with community. And so he used the phrase, you know, the antidote to heroin is not just naloxone, it's also connection and community. And he used the example, by the way, of his own life, where when he was growing up, and he grew up in California, suburban neighborhood, he talked about how his mom would ring the cowbell when it was time to come home for dinner because he was outside playing with his neighbors. He said, I go back to that neighborhood now, there's not a soul on the street. Mm-hmm. They're all in their houses playing their video games and doing whatever. He didn't mean to castigate, but his point was well taken. So much of what we deal with and so much of what we're dealing with this opioid epidemic and why we're trying to do things like recovery centers and clubhouses and peers is we've got to reconnect with people. All the things we're doing will make it easier for people when they want help to get it. But if we don't deal with these deeper issues, we'll never get to where we need to get to, which is eliminating the loss of any life. So, you put this in. I get in trouble for this one. It's a takeoff on the Serenity Prayer, part of it. We saw this, I posted it, I got yelled at I was told I was sacrilegious. But so much of what we've talked about is exactly what this young lady's board says. I am no longer accepting the things I cannot change, I'm changing the things I cannot accept. That's sort of our motto at OASAS. It's been the governor's motto about how we deal with this epidemic. It's been our commissioner's motto. It's how we roll. It's the only way we know at this point. It's the only way we believe we'll ever get to where we need to get to. So all due respect and no offense meant to anybody who would take it. So here are some of our resources. There are plenty. You can find pretty much everything we've talked about if you go to oasas.ny.gov, our main website. It will lead you to all these places. This video will ultimately be posted on our website, so please, all of these resources are there for you to use. Everything we've done, there are all kinds of other videos we've created. Mm-hmm. There's versions of us that were significantly, well, at least in my own stead, slightly heavier than I am at this point. But they're all intended to educate, so please, they're yours. We work for you. Take advantage of them, use them, and as importantly, tell others, right? We post stuff on our social media, share our information. We make it all available. It's, you know, you pay for it. It's intended for you to use, but we encourage you as we're trying to do this as a community, share it with other folks. Great. So here's contact information for Counsel's office, my office, and Tricia monitors that multiple times in a day. Yep. And the Ombuds email, Stephanie monitors, so please use it. The 888 number is monitored by our contracting parties. It's there, option 3, correct?
Option 3 is CSS.
So please take advantage of these and educate others. Tell them about this. So with that, we are done. I want to thank you guys for what you do and for being here to help guide us through this presentation. And I want to thank you. Please use these resources. Help us get to where we need to get to and end this epidemic that is the opioid epidemic. Thank you and have a great day.
I'd like to thank our presenters for today's program. I hope you will all find it useful while assisting clients in need of services. Your feedback is important to us. It helps us to know if we are meeting your educational goals and expectations. Once you have viewed the presentation in its entirety and completed the quiz, please follow directions to access the SurveyMonkey website and take a moment to complete the evaluation. Once again, thank you for joining us and keep up the good work.